So it was really nice talking to you in regards to the um, setting up the corporation, and myself and the audience has some questions on how to, once you get the corporation set up, how do you distribute the shares? You see this on television all the time, that company does this, company that does that, people buy this, people buy that. But for the small company or startup company who has barely, they may not be public, but they want to distribute the shares. I know there's certain steps and certain distinctions of the shares. So can you walk us through the process on how that works?
Absolutely, Joe. Yes. So anytime a company is issuing shares, issuing stock, or even issuing units, when it comes to an LLC, that process in itself, it has to be registered with the SEC, which is this Securities Exchange Commission. That's what that stands for.
Okay.
They are the governing arm of this type of transaction. So when we say securities, the shares, the stock, and the units, they all fall underneath the definition of securities. Now, the SEC says if you want to issue shares, if you want to issue stock to anyone, including the founders, including the employees, including investors, you have to register that with the SEC. Now, that gets very expensive. Registering your company with the SEC is literally like doing a mini IPO. And so companies, the smaller companies, said, well, we can't afford money to register our companies with you. So what do? That's when the SEC came up with some exemptions to the registration. So the questions that have been posed, again, from you and the listeners here is, can my company legally offer and sell securities without registering with the SEC? Well, the answer is yes, Joe. Now, usually legal is never, ever this straightforward, right? So, but the answer is yes. However,
of course, there's a however every time.
Exactly. There's always a however. Otherwise, you wouldn't need lawyers, right?
Right.
So
True.
Exactly. However, the offering that you are giving to someone, the selling of the stock, it has to fall under an exemption. And there are three major exemptions that at least one of the small companies would fall under. And I can briefly go through them. And so the first one would be just the general solicitation rule, and that is 506-C. That's the rule under the SEC Act. And what that allows is it permits the use of general solicitation. So if you're looking for money in exchange for stock, you can actually do a general solicitation, send out an email, send out a newsletter, send out some sort of marketing material. But the purchasers, they have to be accredited investors. So accredited investor is also defined under the SEC rules, right? It's a definition of a person or a married couple, and they have to have at least $350,000 worth of assets, not including the home, or 150 if you are a single person. So you have to have that much in assets for you to be an accredited investor. So that's one exemption. If you do a general solicitation to an accredited investor and you sell them stock, then you don't have to register with the SEC. That's usually the main exemption. A second exemption, and it's been quite popular over the span of 5 or 6 years now, Joe, and we're talking about crowdfunding, right? We're talking about all these platforms that are out there. Now, crowdfunding, which is obviously a regulation crowdfunding, that's what the exemption is called. It's called a regulation crowdfunding. That enables certain companies to offer and sell stock on an internet-based platform through an intermediary that is a registered broker dealer. So for example, we've got Kickstarter. We have other platforms. Some of them escape me now, but they're very popular nowadays, especially with startup companies. And so they have to be a registered broker with the SEC. So that's another exemption, right? So if you're going to do some sort of raising of funds through one of these platforms, you're allowed to under this exemption. There's another exemption, and that's called Regulation A. A is in alpha. And this exemption is from public offerings, right? Regulation A basically is a exemption from the registration itself for public offerings. And what that means is if your company is obviously looking to go public, you would use the exemption under Regulation A. But for most of the time, I'm going to say at least 80% of the time, Joe, small businesses that are just starting out, they want to issue stock to the founders, right, to say thank you for putting in your sweat equity. They want to issue stock to maybe some private investors who want to invest in the company. All of that would usually fall under the general solicitation rule, which is 506-C.
So the founders and those private people that come in or they've been working to support the founder on getting the company ready, those people, based on that description, they have to be accredited investors?
Absolutely, yes. They have to be an accredited investor. However,
okay, please continue.
Exactly. There is an exemption to that as well. So as long as you disclose, so for example, grandma, right? Grandma is retired and grandma has she's probably got about, $40,000-$50,000 that she wants to gift you, and she wants to say, I want to put this in your new company. I want you to have it. As long as you disclose all the risks that are involved with that investment, you're okay to take the investment under that rule. If you don't disclose, if you say, Grandma, I'm going to come back and make you millions and millions, you're going to be great, and the company goes belly up, well, you, under those circumstances, are going to be responsible to Grandma to make her whole. Okay. But if you say, Grandma, this is a brand new venture, there's a huge risk that this may fail. It's a private company. Nobody knows us right now, but your investment will go a long way. And I can either, guarantee it by considering it a loan, or, you could just gift it to me and it will be a gift that I put towards the company. Now you're disclosing that the company isn't private. It's private. It could fail. What could go wrong with a business could go wrong. So that's disclosing information to Grandma. As long as you do that, then absolutely you can issue Grandma some stock under Rule 506C.
Okay. Well, that's very clear and concise and to the point, that definition, especially with Grandma. Nobody wants to get Grandma upset.
Yes, please don't make Grandma upset.
Yeah, no, John, listen. And so what many companies, and I've seen they do, or they may do, or they seem to be doing, is basically they get their shares, they get a little binder where it has like 10,000 shares, and then just write down number of shares for the people who have been helping them with no exchange of dollars. They just, hey, you help me out, here's, 50 shares, 1,000 shares. So that is a no-no?
Depending on what you want to do with a company. If you want to keep the company small and it is a closed corporation, which means literally it's family owned, right? In those situations, you can issue stock to whomever you want, as far as they fall within the exemption. However, if you are looking to grow your company and you are looking for outside private investment to come in to help you grow your company, issuing stock to everyone that's helped you at the beginning in that scenario would be a big no-no, because that's a huge turnoff when it comes to investors. Investors don't want to see, 100 people with half a share here and 2 shares there and 5, they don't want that. So the best way to do that is, yes, say for example, I can't do math very well, Joe. So
All
we'll
right.
just keep the numbers small, right? So
Sounds
let's
good.
say we have 100 shares. Out of the 100 shares, you're going to take a portion. It could be about 30 or 40% that would go towards the founders, the main people that have literally founded the company, right?
Mhm.
And I would not recommend to give them shares outright. I would put them on a vesting schedule. Investors like to see that. Why? Because now that person's vested in the company. They're not just going to take the shares and leave. They
Right.
actually are going to work for those shares, right? So you can give them some shares up front, but the rest of them can vest over time, 2, 3, 4, 5 years. Investors love to see that, private investors. And the other portion, usually about 15%, you would carve out of the 100 shares that you have.
Mhm.
And that would be more for management and executives, because you do want to incentivize someone to work with your company. And for that, you're giving them money, yes, but you're actually saying, we want to issue you stock too. So again, that's incentivizing the employees. And then the remainder of it would be obviously for private investors.
Okay. That's a good point of clarification when we're talking about distributing shares. So if the company is a corporation, is the intent of the owners or the founders is to make it grow at some point, then they're gonna go public, and the moment they publish that,
Excuse me.
sure, the moment they publish that, they will they become part of the SEC regulation. But if they wanted to keep it close, tight, and then basically, if I start that company and I give shares to my friend here and my other friend there and my brother, and and that is a very kind of maybe 1 or 2 neighbors, whatever. So that's not really publishing it to make it kind of look like I'm selling stock. I'm just distributing stock. In those scenarios, that it's okay to do it that way. But if I'm going to publish it and I'm going to publicize it and I'm going to go in as the public for it, then I have to do the disclosures. I got to fall under those. And most importantly, probably call you and say, I'm going to do this. What are my next steps to make sure I don't step in a mine and basically make mistakes and get myself in trouble, even though my intentions are right, but my actions are not correct, right?
That's absolutely correct.
Okay.
Yes. Yes.
Yes. So you and I talked about before about the blind spots in business, and there are so many blind spots in business that we need people with the knowledge, I call with the light, to kind of guide us through the process. And I'm very thankful that you are one of those people who are helping us through the process and answering all these questions in a very concise way. So it's clear to us what we can and cannot do, and where the regulations are set up, even though they're set up to protect people, but they also can people get in trouble for stuff like that. So,
Absolutely.
okay. So, and I would like if you can expand more into the online solicitation side a little bit more. So I know that's something that is, I have a lot of questions from my clients on how to do that. And I say, well, I will ask that question, but if you can clarify a little bit further, if someone starts a company and it has a C corporation or an S corp, well, yeah, C corporation, then and they want to go into a crowdfunding platform, is any preparation, anything that they need to have in place before they do that? Can you go over that again?
Right. So if they're trying to raise money on a crowdfunding
Mm-hmm.
platform, well, each platform has their own rules and regulations, and they have to abide by those, which means that you have to abide by those too, because they are a broker dealer registered with the SEC.
Right.
Now, that being said, sometimes you can actually raise money by either saying we'll give you a product in return, or you can say we'll give you some stock in return. Again, each platform is different, so you really have to understand. And I would recommend even sort of talking to 2 or 3 different platforms out there, because they've got their own different pricing. They have their own amount of how much you can raise, and if you don't hit that mark, then that means you don't get anything. So there are different rules for each platform, but I would obviously have to look at it separately to figure
Right.
out what the differences are. But I think the major difference would be, again, the pricing that you pay. Is it either a product you're giving people, or is it going to be a part of your company that you're going to be issuing?
Or just flat out investment
Right.
on potential earnings, so that kind of stuff. Anything
Right.
like that. Okay.
Exactly.
Very good. Very good. Okay. So, well, thank you very much. That was very informational. And then anything you would like to add in addition to that? So when someone starts a company and they want to raise funds, is an easier way to do anything like this?
Well, one of the ways that companies usually raise a lot of money, Joe, it's through something that's called a private placement memorandum. A private placement memorandum, a PPM, that's where companies that are raising anywhere from 150,000 all the way up to $20 million. It's a document that you provide to potential investors. They're very, very familiar with these documents. And in that document, you're going to list out all the risk factors, because you, as a company, you want to limit your liability. So, for example, say you provide this document to a potential investor, and all of a sudden you didn't capture in there that your country or your business is barred from doing business in Canada, right? And you didn't put that in there, but the investor relied on thinking, well, you do business everywhere else, why not in Canada? Well, they can actually sue you for that, for not including that in the risk factor. So it's going to be really, really legal specific. Definitely have to hire an attorney to draft one of these. They can be quite costly. The bare minimum starting of these PPMs, you're looking at anywhere from 10,000 all the way up to about $30,000, $40,000. That's what people pay at the big law firms, because it's a very labor intense document. And again, it has all the exemptions in there, but that's for someone that's raising some really serious money from some serious investors, that this is what they do. They're very familiar with that document. If anyone has a question about issuing stock, it's always a great idea to reach out to you first, or reach out to me first, because it's easier to prevent a mistake than actually making it, and then you have to go back and correct it. And usually those are very costly as well.
Yes. It's my dad used to say it's really easy to prevent spilling the wine, because it's very hard to clean it.
There you go. Absolutely.
What do you mean by that? But now, as you grow older, you know exactly what he meant.
That's exactly it. Yes,
Yeah.
Joe.
So I do have a question that just came in, and it's really quick, and we can cover next time. But he says the 1980s or so, 1990s, there was a private placement, was called SCORE, SCOR, he calls it, private placement, where people they used to sell shares. Is that even available nowadays? Or that's for private companies?
Not to my knowledge,
Okay.
Joe.
Yeah, it's been a while, so I'm sure the laws have changed a lot.
Definitely.
So, okay. But I'll have him send you an email with that information. He didn't post much on the chat, so I'll send that information to you and see. Maybe there's things have changed. Like,
Perfect.
I didn't know they had the crowdfunding regulation until you mention it right now, which is a totally different ball game on the way the things were used to be done even 5 years ago.
Absolutely.
So it's changed really fast.
Yes.
So Kelly, thank you very much. I really appreciate your insights in the legal information that you provide for us today. Very educational, very powerful. and a lot of money savings by not making the mistakes. But Kelly, I know we have a disclaimer. We usually do it at the front, but I want to do it at the end. And could you give us the disclaimer, and also how do people can reach you?
Thank you, Joe. Yes, any information that I share on Legal Tuesdays, it does not create a client attorney relationship. It's only general information for educational purposes. That's the disclaimer. And I'll be more than happy to hear from any of your listeners. They can contact me directly, Kelly at baglaw.com. That's BAGLALAW.com. Or they can call me directly at 760-784-9109.
Excellent. And we'll include those notes in the YouTube section. That way people can actually read it, hear it, but also read it when and they can get in touch with you. And again, it's been an excellent session as always, and very thankful for your contribution of your time and your knowledge to our veteran community and to the community in general, and for being so awesome attorney. I mean, just I can't say that enough times.
Thank you. Thank you, Joe. Thank you very much. And we certainly do love our veteran community.
Absolutely. Yeah, and thank
Yes.
you. Appreciate it. Okay, so until next time, we thank everyone for participating. And if you have any questions, you can just email us through our website, www.dcsd.org, and then we'll get those questions to Kelly for her to answer, or just contact her directly, and she will be more than happy to take care of you. Until next time, we'll see you then.